Hi, my name is Chris Yukins. I'm a professor at George Washington University Law School in Washington, D.C. And welcome to this next module in our course, United Nations Guidance on Anti-Corruption and Procurement, sponsored by UNOPS and the International Anti-Corruption Academy. Welcome to this module 5 on Remedies and Bid Challenges. Thank you for joining us. While bid challenge systems are called for by the UN Convention Against Corruption, they can be called different things in different countries. In some countries, for example, they're called bid protests, or they may be called bid challenges or remedy system. Fundamentally, they're all the same thing. They are a judicial or administrative mechanism for disappointed offerors to challenge an award, or even before an award for a bidder that feels is being discriminated against, to challenge the terms of a solicitation. This is a very important anti-corruption device, but more broadly, bid challenges are also a very important part of a healthy procurement system. So a review and remedy mechanism is a key feature of any effective system of public procurement because it allows stakeholders, including competitors, to monitor compliance with the applicable rules and to enforce them where necessary. It allows the enforcement of public procurement regulations in cases where procuring entities, agencies, either intentionally or unintentionally fail to comply with public procurement law. So a couple examples. There could be a bid challenge where a contract isn't publicly advertised but is awarded directly to a company in return for a bribe, or where a technical requirement is tailored to a particular company because of a bribe, or a responsive bid is ranked first and rejected because of a bribe. These are examples of where bribery or outright corruption can be brought to light through a bid challenge mechanism. A bid challenge or a bid review process fosters public confidence in the procurement system as a whole, and a public procurement rule system without an effective and rapid legal remedy system is arguably toothless. Put differently, the bid remedy system, the bid challenge system, the bid protest system offers a ready means for procuring entities, for governments, to do risk assessment, to mitigate risk that the procuring system is going awry, that there's corruption, or that the procurement rules have been violated. Bid challenges or bid protests can be brought in 3 different fora typically. International best practice is to allow bid challenges in a country's courts, in an independent agency in the country, and also to allow challenges at the procuring entity or the procuring agency itself. Some countries or some governments may not allow all 3 fora, but an international best practice is to allow for challenges to be brought in any of these 3 fora. And we'll be discussing that more over the subsequent slides. It's worth stressing that all important international texts on public procurement promote remedies or bid challenges in public procurement. The UN Convention Against Corruption, as we've been discussing, calls for an appropriate system of public procurement to have and include an effective system of domestic review. The World Trade Organization Government Procurement Agreement, which is the leading international trade agreement on trade and procurement, says the GPA parties must provide timely, effective, and non-discriminatory administrative or judicial review procedures. And finally, the UN Commission on International Trade Law, the UNCITRAL Model Law on Public Procurement, includes a recommendation that bidders should be able to challenge apparently non-compliant decisions in the procuring process through a bid challenge mechanism. So all these important texts on public procurement internationally all call for creating an effective bid challenge system. So let's talk about what the key components are for a successful bid remedy system. The review body, and this can be a court or a independent agency. For example, in the United States, the Government Accountability Office is an independent agency, an arm of Congress that hears bid challenges. The independent body receiving the application for review must be independent from the procuring entity, so that it doesn't have a conflict of interest. The procuring entity ideally shouldn't be left with sole authority to decide whether its decisions were in line with the regulations. A third party should review the decision of the procuring entity that the decision that a bidder alleges is not in compliance with the law. That's the importance of independence. This might be a third party review, as I said, a judicial review or an administrative review by, let's say, an independent agency. An additional element is a request for reconsideration. So some systems require that a disappointed offeror or a bidder who wants to bring a bid challenge first go to the procuring entity to reconsider its decision before that challenger can turn to an independent body. This allows the procuring entity an opportunity to correct its own decision, and if the applicant is dissatisfied with the decision by the procuring entity, the applicant or the challenger can immediately thereafter commence proceedings before the independent body. So another question in assessing what makes an effective bid challenge system is the question of what's a contestable decision? Which decisions or actions of the procuring entity can be challenged? Good international practice suggests that any decision or action by a procuring entity can be challenged. Some jurisdictions allow challenges, though, to only certain decisions of procuring entities, such as publication or the tender documents, exclusion of a bidder from a second stage of a competition, or other determinations during the deadline for bid submissions. Sometimes they only allow challenges to clarifications or adjustments or corrections, or to the award decision itself, or to a cancellation notice. The point here is that some systems can decide that certain elements of the procurement process are immune from bid challenges. There's a downside to that, though. The downside is that, and experience has shown that when a country or a government, an agency, shields certain aspects of the procurement process from review, from accountability, very oftentimes it can have a perverse effect on the procurement process, where the procurement process is actually molded by the procuring entity, by the agencies, in order to avoid those elements that might be subject to bid challenge or bid review. It has a perverse distorting effect in the procurement system overall. So international best practice is better instead to start from the presumption that everything's going to be subject to potential review and a bid challenge, and therefore subject to accountability, to transparency, to restore and reinforce, guarantee the legitimacy of the procurement process in the public eye. So the next question in assessing what makes an effective bid protest system is who should have the power to file a complaint? Who should be able to bring, for example, a bid protest? Who has the right to commence a review proceeding? Should it be everyone? Should it include civil society organizations, or only those firms that submitted a bid? Good practice has suggested based on experience in many nations, that any company that has or has had an interest in a particular contract and claims to have suffered or claims that it may suffer a loss because of a breach of public procurement law should be able to bring a challenge, such as a prospective bidder that wants to challenge the tender documents before the bid submission deadline, arguing that a particular award criterion, for example, is discriminatory, or a disappointed bidder arguing that the bidder with the lowest price submitted a non-responsive offer. What's increasingly emerging on the international stage as these systems of bid challenges mature is a recognition that the bid challenge mechanism, the bid protest mechanism, isn't really a mechanism for vindicating the rights of bidders so much as it's a risk control measure for public agencies, for governments. In that light, this question of who should have the power to file a complaint, who in U.S. terms, for example, in American terms, who has standing to bring a bid protest, this question becomes more elastic, because if the real goal is risk mitigation on the part of the government, the real goal is to identify risk and possible failures or even corruption in the procurement system, it makes sense to take a more flexible approach to the question of standing, a more expansive approach, because the government has a broader interest in allowing more people, more potential challengers to come forward in order to mitigate the risk that the government suffers. Now, the accountability consideration is that by allowing more people to bring challenges, one increases the risk that bid challenges will delay the overall bid process, or the overall procurement process. So those are the two interests that have to be weighed. On one hand, the government's interest in risk mitigation and allowing broader bid challenges. On the other hand, the desire to ensure that the bid challenges don't unduly delay the procurement process. So let's speak for a minute about the available remedies under a bid challenge system. Now, we spoke before that a bid challenge system can be understood really as a whistleblower system, as a system to ensure that governments find out about failures in the procurement system, including potentially corruption. So if this really is a whistleblower system, the remedies should be viewed in that light. The remedies are really incentives to the whistleblower to come forward to bring a bid challenge. And those sometimes have to be very strong incentives, because in some systems, in some countries, some cultures, bringing a bid challenge can be viewed as very offensive by the procuring entity. If a contractor or bidder brings a bid challenge, that can really prejudice that bidder or that vendor in future contests and future procurements. So the incentives for that bid challenger to serve as a whistleblower in this what we would call a private attorney general system in the United States, the incentives sometimes have to be quite strong. Now, there can be interim measures, such as provisional measures to maintain the status quo. In particular, measures to prevent the bringing of a public contract into force, which may be irreversible. So to avoid that, in order to make sure that the contract remains open, remains an incentive to the whistleblower, this may mean suspending the implementation of any decision by the procuring entity while the bid challenge is pending. So that's the first option, is to maintain the status quo, to make sure that the contract isn't awarded so that the bid challenger feels like there's a potential prize down the road. It's an incentive to bring the bid challenge. The second possible approach is setting aside the procuring decision, which is sometimes referred to as corrective action. This is an effort by the procuring agency or otherwise to correct proven irregularities. This often means annulment or positive correction of an unlawful decision by the procuring entity. It's a complicated way of saying there might be a recompetition with the error erased on the recompetition. A third approach is damages, to actually make compensation to the supplier who's harmed by an infringement of a public procurement law. This can be an alternative to corrective actions if, for example, the outcome of the bid challenge is unduly delayed, takes months or years. There may not be any contract to contest anymore, so the only available remedy might be damages to the bid challenger. There could also be limitations built into the law on the amount of damages, or in some systems there's no damages allowed at all. Some systems allow limited damages, such as a compensation for bid or proposal costs or perhaps attorney's fees. Some nations allow much larger damages based on anticipated and lost profits. So different systems take different approaches to the types of remedies that can be afforded. Again, the emerging international best practice is to think of this not just as a way of compensating and remedying any wrong suffered by the individual bidder, but more importantly, how to set up a remedy system, to set up an incentive system, so the whistleblowers, so that vendors who are involved in the process actually come forward when they recognize a failure of the procurement system or recognize corruption. So if we're going to have an effective bid challenge system, how do we ensure that the contract will remain open, that remains an effective incentive for a bid challenger to bring a challenge? One approach, and this is especially common in the European Union, is to impose a standstill period on all awards. This is a standstill period between the decision on announcing the successful bidder and the actual contract award, so that this is during the standstill period, the award is not yet made. This allows a potential bid challenger who wants to challenge a non-compliance with regulations to come forward to address this violation of the regulations before the contract enters into force. The alternative is to have a race to the contract signature, where if an agency or a procuring entity can preclude contract or bid challenges, it will award the contract rapidly if that, as a legal matter, if that bars any bid challenges. In order to avoid that unseemly race to the contract signature, the standstill period maintains the status quo for a certain period of time, a matter of days typically, during which time a bid challenge can be brought. The deadlines have to ensure that companies have sufficient time to challenge a decision, a certain period of time from when the basis of the challenge became known. For example, there can be a requirement that a bid challenge be brought within 10 days of when a vendor knew or should have known that there was a ground for a bid challenge. Good practice suggests allowing a minimum period of time to prepare a bid challenge, because bid challenges can be very complex to prepare. Allowing a prospective challenger adequate time to prepare the challenge means that the whistleblower system we've been talking about, that the system that allows the agency or the government to find out that there's been a failure in the procurement process, will work effectively. Another key component of an effective bid challenge system is the access to the procurement file. How much of the administrative record, for example, will be made available to the bid challengers? Access to the record is essential for the verification of compliance with tender documents and specifications and to ensure that there was an objective assessment of the bids or proposals of the agency. There wasn't discrimination or corruption, and it was done in conformance with the specifications and the governing rules. Only by allowing access to the administrative record can you achieve that kind of certainty. So good practice suggests that challenger in a review procedure should be entitled to inspect and comment on the evidence and observations submitted to the reviewing body. That means in practice that if an agency is defending a bid challenge by submitting certain record documents from the administrative record, the challenger should be allowed to review those documents. But that can raise problems because if that information that's being submitted by the agency to the reviewing body, if that's proprietary information from other bidders, for example, or internal information from the agency that would give the challenger unfair advantage in future procurements, what we in the United States call source selection information, then we have to restrict the challenger's access to the procurement record or subject to some sort, for example, to some sort of protective order to limit the access. It should be limited only insofar as is necessary to protect the business interests of the challenger's competitors. In some systems, counsel and experts are afforded access to commercially sensitive information on their commitment not to participate in future competitive decision-making. Again, for example, under a type of protective order. Generally denying all access is contrary to fair competition. If bidders who are challengers are denied all access to the administrative record, that really raises a risk regarding fair competition. In some systems, the awardee is also allowed to participate in the proceedings so that a bid challenge, so the awardee, the vendors that actually won the contract can participate in the proceedings. This is a sound way to protect the awardee's interest in ensuring that there's a fair review process. Because bid remedy systems are so common around the world, it's worthwhile sharing examples from different countries and also to assess how the remedy system in your particular country works. Is there a tradition, for example, to file bid challenges, or is there a countervailing tradition, a reluctance on the part of vendors to bite the hand that feeds them, to challenge the agencies that are their source of future income? It's an interesting cultural, social, and legal question. And it's a better way of understanding how the bid protest system or the bid challenge system works in an individual country. I hope you've enjoyed this module on bid challenges and bid remedies. Thank you again for joining us.